What's the problem, counsel?
Problem is that this witness is not on the prosecution's list.
As counsel is aware, this witness only recently came to light via an article in the press. And Mr. Haller spoke with her before I did, so he can hardly claim to be blindsided.
Which is how I know the witness has no relevant information.
His argument halfway through, and frankly, the first argument was actually a whole lot better. You weren't aware of the witness, and the prosecutor didn't make you aware by putting them on the witness list. That's your best way to not get this witness to testify. Saying that they have no relevant information, of course, the prosecutor is going to say, then why would I even want to call them? Of course they have relevant information. We're not going to waste my time or anybody else's. That's a weak argument, and frankly, I think Mickey, being the attorney that he is, would stick with his first argument.
She had a front row seat to the relationship between the defendant and his wife.
Yeah, 10 years ago.
Which sounds like something you can bring out on cross if you like.
You can have a standing objection, Mr. Haller. If the witness has nothing of evidentiary value, I'll strike her testimony and instruct the jury.
And his mistake there put the witness on the stand, because he changed horses in the middle of the race and said, oh, well, at first, they're not on the list. And then, they don't have any relevant information. And the judges only heard the second argument, really, or only ruled on the second argument right then and said, well, if they don't have any relevant information, then I'll tell them to go have a seat.